The guardian of the estate, it needs to be somebody who can get things done, who will take care of things, who won't neglect the investments, who won't neglect the assets. They don't necessarily have to have a lot of financial knowledge or savvy or wherewithal. They can hire a financial planner to help them. They can hire an accountant to help them, but they need to be somebody who's going to take care of things.
Welcome to Absolute Trust Talk with your host, Kirsten Howe. Absolute Trust Talk brings you tips, tools, advice, and interviews to help you build a reliable knowledge base on estate planning, business, and finance to start preparing for your future today.
Welcome to Absolute Trust Talk. I am your host, Kirsten Howe, and today we're doing another Facebook Live version of our podcast here at Absolute Trust Council. We are going to be talking about guardianship. A lot of our clients, when they come to us to do estate planning for the first time, they are thinking, oh, well, now we own a house, now we have investment accounts, we have bank accounts, we better get serious and do some estate planning. But the truth is that really the most important thing in your estate plan, if you have minor children, is the nomination of a guardian. And that is a reason why really you ought to do estate planning, even if you don't have a house, you don't have a big bank account, a big investment account. If you have children, you need to do estate planning. That is by far the most important thing that your estate plan will do for you, is take care of that guardianship issue. So we're going to be talking about guardianship today. I will talk for a little while. This isn't a real long episode because it's just me, no guest. If you're listening to this later, I'm sorry, I can't answer those questions, but you can always give us a call or send me an email, and I'd be happy to answer questions for you. Okay, so back to the matter at hand. We're talking about guardianship. And just to give you the basics, there are two kinds of guardians in California. There is the guardian of the person and the guardian of the estate. So the guardian of the person is the person who's going to step in and basically be the parent. If something happens to you, the person who's going to raise your children, the person who will have the legal responsibility for them and the legal authority that goes along with being a parent. They'll be able to register the kids for school. They'll be able to sign permission slips and consent forms. They'll be able to take the kids to the doctors and make medical decisions for them. Because when a child is not 18, they can't do those things for themselves legally. They have to have either a parent or a guardian to do those things. So that's one kind. And the other kind, as I said, is the guardian of the estate. And this would be the person who has legal responsibility for and authority over your child's assets. If your child has any assets and they are a minor, they would have to have a guardian of their estate, because a child under the age of 18 legally can't open up a Charles Schwab account or manage their investments. They have to have an adult do that. Sometimes in some families, the parents would like for the same person to be both the guardian of the estate and the guardian of the person. But that's not always the case. Oftentimes parents pick different people for those two different jobs because they are different jobs. The guardian of the person is, a very, very, very important job, and you want to select that person carefully. You would like, if it's possible, for them to be someone that your children know and like. You'd like for them to be someone whose values are similar to yours, who will raise the kids the way you would like them to be raised. Maybe you want them to have the same religious beliefs as you have. So those kinds of decisions are important when you're thinking about who would be the parent if something happened to you. And if they have children of their own, you want to pay attention to what kind of parent they are to their own children. And just imagine how it would be for your kids to have them as a parent, and before you make a choice. And sometimes making that choice is very hard. Sometimes I've heard from many of my clients who do come to me to do estate planning say, well, we just put this off for so long because we couldn't decide on a guardian. So I know it's a hard choice, but it's better to make the choice than to not make the choice, is my position. The guardian of the estate, it needs to be somebody who can get things done, who will take care of things, who won't neglect the investments, who won't neglect the assets. They don't necessarily have to have a lot of financial knowledge or savvy or wherewithal, they can hire a financial planner to help them. They can hire an accountant to help them, but they need to be somebody who's going to take care of things. They need to be someone who's responsible, just like the guardian of the person. So these are difficult decisions, but it's better that you make them than that you leave that to somebody else to make that decision. So I'm going to talk to you now a little bit about the process for how guardianship works, because I find that most parents don't know this. When you are the parent of a minor child, you want to, in writing, nominate your preference for guardian. And then if the time ever comes that your child needs a guardian, that person will file a petition in the probate court asking the judge to appoint them as the guardian. So the parents can nominate someone, but only the judge can appoint someone. And it's a legal appointment. There has to be an order. There has to be a judge's decision that this person is the guardian. So the prospective guardian files their petition, and then they have to serve that petition. In other words, mail it out to various family members so that all the close family members will know this person wants to be the guardian of these children. And the family members will have an opportunity to put their 2 cents in. They'll have an opportunity to object, or they'll have an opportunity to say, I don't think this person is a good choice for a guardian. I think somebody else should be the guardian. So they'll have an opportunity, assuming nobody does object. Typically, the court will grant the petition, and then that person will be the guardian. But it's not a done deal. If family members object, the judge has to look at that very carefully and decide what's in the best interest of the children. So it's important for you as parents to get your choice in writing, because the judge will look very seriously at the parent's choice. The judge will want to appoint the parent's choice unless the judge sees good reason not to. So you really want to express your wishes in writing. We do estate planning to make sure, first of all, that our wishes are honored. So that's very important. We also do estate planning in many cases to try to avoid having to go to court. Now, if something happened to you and your children are minors, they will have to have a guardian of the person. We really can't avoid that. But we can avoid the guardian of the estate. If you have a will, a trust, if you've written out what you want to happen to your children's inheritance, that's what'll happen. And we don't have to worry about having a guardian. But it's very important to remember that if you leave assets to your children who are minors outside of your trust, such as you make them the beneficiary on a life insurance policy, or you make them the beneficiary on a retirement asset, and they're minors, then there's going to have to be a guardian of the person. So much better do an estate plan, set up a trust, and make the trust be the beneficiary of those life insurance policies and retirement assets. So that's how we avoid going to court on that piece of it, on the guardianship of the estate. The last thing I want to talk to you about is something that we do for our parents of minor children. When they are doing estate planning, we think it's a good idea to not only name someone to be the guardian, but to give them information, give them guidance, let them know what the job is. So we have this, it's a guide to writing what we call a letter of intent. And what the guide does is it kind of walks you through step by step the things that you probably should let your guardian know about your child now. Does your child have allergies? Does your child take certain medications? Is your child being treated? That whole medical stuff. What is your child like and not like? What are your hopes for your child? Just helps you think about the things that maybe a guardian would like to know. So this guidebook, if you're watching live, you'll be able to click on a link in the comment section and it'll take you right to the guidebook. But it's also available on our website, where all of our other guidebooks are found. So that's absolutetrustcouncil.com. And I think the button is called resource, and you'll find it there probably eventually, but I think it might be up there right now. Okay, I'm going to look to our comment section and see if we've got any questions. Let's see. Okay, this is a good one. Does the guardian get paid? So the answer to that is yes, a guardian can get paid for their work. The guardian gets paid on court approval. So the guardian does their job, and then they have to go back to court and ask to be paid for services rendered. But yes, the guardian can get paid. Okay, what can someone do if there is a family member they definitely do not want to be the guardian? Okay, that's a great question. What I recommend is, in addition to nominating your choice of guardian in a separate writing, you can write a letter or a memo or whatever you want to call it, but definitely sign it and date it, explaining, first of all, why you chose the person you chose. And if there's somebody that you really don't want, you might want to write in that letter or in yet another letter the reasons why you don't think that person would be a good choice. Because remember, you're not going to be there, and all the judge has to go on is your nomination and whatever anybody else has to say. So it would be really nice if your choice of guardian had a little bit of evidence to back up their petition. So I recommend writing that in a letter or a memo that eventually a judge will read. Okay, what happens if the guardian dies? Okay, so if the guardian dies, then somebody else is going to have to petition to be named guardian. We always recommend that our clients not only nominate a guardian, but they nominate an alternate or maybe two alternates just for that situation. Because again, what's most important is that you have a say, because you're the one who knows your children and you're the one who knows what's best for them. So that's what happens. The guardian dies. We go to plan B, ideally. Okay, I don't see any other questions, so I'm going to wrap this up. I'm just going to remind you, this episode will be available on our website. The guidebook, the resource, is also available on our website. We are here at Absolute Trust Counsel to help you with any of your estate planning or estate administration needs. We're open, even though COVID is raging all around us, but yeah, we are here to help you. Thank you very much for joining me, and I look forward to connecting with you next time.
Thank you so much for listening today. I really appreciate you being here. I am so grateful that you're in my audience, and I hope you also learned something and enjoyed the show. If you like our podcast, be sure to go to iTunes and subscribe. You just type the words Absolute Trust Talk in the search bar on your podcast button on your phone, and our podcast will come up and you'll be able to subscribe there. That subscription helps us with our visibility online, our SEO, and all those kinds of things that I never understand, but I'm told that it's important. So in addition to searching for us on iTunes on your phone, you can also just go to our website and you'll find our podcast there. You'll also find all of our previous episodes. So you go to absolutetrustcounsel.com, click on the podcast tab on our homepage, and you'll see all the topic for all of our previous guests, and you just click on the one you want to listen to. Also, make sure to catch our next episode, which will be out in a month or so after this one, and I know you'll get a lot out of that one too. So I look forward to connecting with you next time.
Thank you for listening to Absolute Trust Talk. If you loved this episode, head on over to iTunes to subscribe and leave us a review. Don't forget to visit our website, absolutetrustcounsel.com, where you can find a host of guidebooks and other tools to help you through the estate planning and estate administration process. If you need help securing your own legacy, then put your absolute trust in us. Give us a call at 925-943-2740 or email us at info@absolutetrustcounsel.com to set up your free consultation today.
This podcast is not meant to take the place of legal advice from an attorney and does not create an attorney-client relationship. If you do have a legal question or issue, please consult with an attorney.